All right, welcome everyone. Can you hear me in the back? Okay. All right, thanks for joining us this evening. My name is John Kitch. I'm an assistant professor of instruction here at the School of Civic Leadership. And it's my honor to introduce to you Jim Stoner. Professor Stoner is the Herman Moyse Jr. Professor and the director of the Eric Voegelin Institute at Louisiana State University, where he has taught since 1988. Jim earned his undergraduate degree from Middlebury College and his PhD from Harvard, studying under Harvey Mansfield. And less importantly to you, but more importantly to me, he's my doctoral advisor. He remains a great mentor and friend. Jim is a towering figure in the fields of political theory, American constitutionalism, and the Anglo-American common law tradition. He's the author or editor of 7 books and many articles. His educational institution building work has taken him from the Louisiana State Capitol to Princeton to Washington, D.C., and even to Iraq. More deeply, Jim is the sort of citizen and leader that we here at SCL aspire for all of you, our students, to become. He strives for and frequently achieves excellence. He has a fearless commitment to the pursuit of truth, and he is both sober and hopeful about the American project. His speaking and writing bring to life both the messiness and the majesty of Republican government. He is a devoted servant both to his state and to the United States. And most fundamentally, Jim is a gentleman scholar that exudes care and respect for his students and colleagues. Tonight, he will speak to us on a constitutional matter, both perennial and pressing. How ought we to understand the politics of executive orders? Does the Supreme Court treat executive orders differently than statutes? And ultimately, what or who is the source of American law? His talk is entitled, Who Lays Down the Law? Congress, the President, or someone else? Jim, thanks for joining us and welcome to Texas.
Well, thank you, John, for that too kind introduction. But fortunately, you did leave some wiggle room by saying I was frequently excellent, which gives me a chance to flub up from time to time. But very kind. It's a great honor to be here at the School of Civic Leadership here in Texas. Can you hear me in the back? Is that I don't know if I'm amplified just for posterity or also for you. I've been following the various civics schools since their inception in Arizona, at Arizona State, about almost a decade ago now, and have been watching very closely. But once a school was established in Texas, that really means it's going to happen in a big way. Or I guess it could fail in a big way, but I don't see that at all, because that is not the character of Texas. You know, Louisiana, when Texas was young, Louisiana was the big rich neighbor, and they saw Texas as this sort of desert out on the edge. And nowadays, well, I won't quite say that the situation is reversed, but when I come to Texas, every time it's grown and it's big. And of course, it always has been, but it is. It's becoming a kind of, I think it's becoming a kind of model for the American states in the way New York once was and California once was. And I think that at this moment, in any event, Texas is the one everyone watches. So I think this project has special importance in that way, the project of your school. So it's an extra honor to be here. Who lays down the law? Congress, the president, or someone else? The question would seem to most any American with basic civic knowledge to have an obvious answer. Congress has the legislative power. So if laying down the law means making law, it's the business of the legislative branch. But laws need enforcement, or they're just words or parchment barriers. So laying down the law might mean making law effective. And that would be the task of the executive, a power granted by the Constitution to the president. Or laying down the law might refer to who has the final say over what the law is. And that would belong to the judicial power, since most executive actions must pass through a trial court before their final execution. Actually, I wrote resolution. Okay, their final resolution. Thus, even without considering the issues of natural law or federalism, or the ways in which the three basic powers of government are mixed among the branches, the question of the source of law is not so simple as the textbooks might imply, nor the question of usurpation or abdication so easy as partisans might assert. In this talk, I aim to provide an overview of the efforts thus far during the second Trump administration to change federal policy through executive orders. In recent years, political scientists have devoted increased attention to this device, particularly as it has been used by presidents to bypass resort to legislation. William G. Howell, in Power Without Persuasion, The Politics of Direct Presidential Action, introduces the executive order as a common and effective practice by which presidents implement their policy preferences without needing to persuade members of Congress, as they must when seeking to enact a legislative program. Following the method of rational choice, he shows that it's often to the president's advantage to act unilaterally rather than propose legislation to Congress and wait around until they act or don't, unless his actions are so far from the preferences of members of Congress that they would overturn him, or so far from members of the Supreme Court that they would intervene. Andrew Rudlovich complicates the story in his book By Executive Order, Bureaucratic Management and the Limits of Presidential Power, showing the complex origins of many executive orders and their limited effectiveness when not endorsed by seasoned administrators. But he does not undermine Howell's basic point, which is to explain the strength of the political incentives encouraging presidents to act unilaterally when they can. Both acknowledge that these incentives operate differently according to the policy in question, particularly whether at issue is foreign policy or domestic policy. And as the constitutional and legal structure that creates the incentives varies according to the matter that's at issue. In this talk, I'll look at executive orders from a different perspective, approaching them not as policy, but as a form of law. Law is sometimes called an instrument of policy. This difference between law and policy, by the way, is often overlooked by political scientists or treated as secondary. Law is sometimes called an instrument of policy, or policy seen as an effect of law. But both these statements suppose that policy is more fundamental than law, the intention of those who govern, or the practical results of the legal process. Although even when speaking from the perspective of law, one does consider the intention of the lawgiver, and one asks whether law achieves its intended result, the mood is different between law and policy. Law is imperative, and obedience is thought obligatory. Policy, by contrast, is optative, what those who govern hope to achieve. Policymakers use law as an instrument precisely because it is thought to oblige others to accede to their wishes. Without discoursing philosophically about duty and obligation, my aim today is to ask not why presidents resort to executive orders to achieve their policy objectives, but whether or how and to what extent such orders acquire the force of law, and thus how they compare to other sources of law and legal authority. That will require a brief foray into the various sources of law in the American Constitution, constitutional order, and to that I'll turn first. Except in Louisiana, the basis of law in the United States, all the Louisianians there, you could see the Louisiana quarter there, they all laughed. Except in Louisiana, the basis of law in the United States is common law, the unwritten customary law carried over by the colonists from England and adapted to their circumstances in the New World. Common law settled questions of property and its conveyance and inheritance, as well as the law governing relations of persons and within families, criminal law, and much else, not least the practices considered due process in the decision of cases and disputes, including trial by jury, called by some the characteristic institution of common law. Common law was not the only form of law in England. Ecclesiastical law was separate, even after the king had been declared supreme head of the church there, as was the law merchant governing commercial transactions, and then the local law of particular counties towns and even estates. Then there was also the sovereign prerogative, the authority of the king. When Sir Edward Coke wrote his Institutes in the early 17th century, he thought it best not to even try to define prerogative. Though as Chief Justice he had decided several cases on matters of common law that King James thought belonged instead to his prerogative. But towards the end of the 18th century, on the other side of the English Civil War, Sir William Blackstone was willing to enumerate and circumscribe the prerogatives of the monarch in his commentaries on the laws of England. By his time, the English referred proudly to their constitution, but it, like the common law itself, was unwritten. To Blackstone as to Coke, it resided in the various courts and offices of the realm, each with its own legally defined authorities, including the sovereignty of what had once been called the High Court of Parliament, comprised now of King, Lords, and Commons. Far from rejecting the common law, the American revolutionaries, for the most part, embraced it, insisting they were entitled to the common law privileges entailed in due process and to trial by jury, which the British denied them by the various coercive acts imposing martial law in response to the Boston Tea Party. The colonists did not accept British assertions of sovereignty of Parliament, particularly over themselves. They acknowledged the authority of Parliament to pass statutes to alter common law in England and to impose taxes on the British people, a power that by then had been denoted legislative, but they believed that legislative authority in America resided in their own colonial assemblies. This was the nub of their constitutional dispute for the long decade from the end of the 7 Years' War to the Declaration of Independence. They rarely addressed the question of royal prerogative, but did begin to refer to the power exercised by the king in England and his agents in America as executive. Until the king declared the colonies outside his protection in August of 1775, in response to the outbreak of fighting at Lexington, Concord, and Bunker Hill, they nursed a constitutional doctrine which imagined a shared executive power in the British monarch with independent legislatures for Britain on the one hand, that is Parliament, and for each of the colonies, that is their particular assemblies. Considering the August Declaration, 1775, to indicate the king's abdication of authority, they cut the remaining cord and began to write constitutions defining their forms of government, except in Connecticut and Rhode Island, which had elective rather than royal governors, and thus no executive to depose or replace. Famously, the executives that they established in Massachusetts, Virginia, and the like were closely controlled by the assemblies. Pennsylvania even established an executive council rather than an office that looked like a proprietor or a king. In short, despite their use of the political theory of a state of nature superseded by a social contract, the American founders did not treat lawmaking as writing on a blank slate. The political order needed to be amended. I say the political order needed to be amended or regrounded, given the break with England and its king. But this was to protect their legal rights, not invent them out of whole cloth. In the states, at least, a new constitutive power was exercised by the people, acting through conventions, or through their assemblies acting as conventions, perhaps on the model of the Convention Parliament at the Glorious Revolution in England. But this constitutive power was invoked only to legitimize and establish institutions of governance, not to construct a comprehensive code. In the states, the reconstituted legislative power could best be described as the power to declare or to remedy the common law, following William Blackstone's rules for interpreting statutes in his commentaries, widely read and treated as authoritative in the young United States, except, of course, on matters related to sovereignty. The colonists generally sought continuity of law, holding that the British, not themselves, were trying to innovate. Everything was different at the federal level, however. Congress was originally an irregular body made up of delegates from the states, each state having one vote. even when its form was regularized through the Articles of Confederation, it did not have legislative power. Let me say that again. That Congress in the Articles of Confederation does not have the legislative power. It could requisition funds from the states. It could determine war and peace. It could regulate various matters and settle disputes. But the only mention of legislative power as such is in reference to the states, prohibiting congressional interference therewith, or more particularly, congressional interference with the duties that they imposed on imports, their tariffs. This changed when the federal Constitution was written, of course. Now, the constitutive power was asserted by the people of the United States, acting through their states in conventions. Congress itself was reconstituted into a bicameral legislature, receiving its power, granted enumerated legislative powers, rather than, like the other two branches, receiving its power as a whole. These included powers to regulate, as in the Articles, now not only the value of coinage, the post office, and the armed forces, but commerce with foreign nations and among the states and with Indian tribes. And explicitly it included the power to make laws that tax, that naturalize immigrants, that settle bankruptcies, that govern a capital district and all other federal property. And finally, a power to, quote, make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any officer or department thereof. The provision for amendment altered the constitutive power thenceforward to the people of only 3/4 of the states, and even as a sort of proxy to the people acting through their legislatures rather than in conventions. After the Civil War, amendments were passed that expanded the powers of Congress to act, quote, by appropriate legislation to enforce the prohibitions against slavery, the guarantee of civil rights, and the protection of the right to vote from denial on account of race, and later on account of sex or non-payment of a poll tax or age, at least if over 18, as well as an amendment giving Congress the power to tax incomes from whatever source derived. If the regulatory powers of Congress were expanded by the Constitution and legislative powers created by it, other powers that belonged to the Continental and Articles Congresses were diminished as it became a proper legislature. It could no longer, quote, determine peace and war, as in the Articles, but only declare war, and could no longer appoint officers of government or make treaties. These functions would now be shared with a separate executive, with Congress generally playing a subordinate role and usually only a part of Congress, the Senate, at that. And it would no longer settle disputes among the states, as a separate judicial branch was also created, though Congress now had the power to establish courts inferior to the constitutionally established Supreme Court. Whether Congress had a general power to provide for the execution of common law, and thus for its amendment, was a question raised in the earliest years under the Constitution and, after some controversy, decided in the negative. Common law would remain in the states. Federal law would be, well, something else. To conclude this foray into the complexities of law and lawmaking at the founding and in the text of the Constitution, let me make a few observations. First, while the legislative power in the states was well understood and took as its model the capacity of Parliament to declare and alter the common law, the legislative powers of Congress were, like Congress itself, something new. Although it would not be accurate to say that they, any more than the legislatures of the states, operated upon a clean slate, since until Congress acted, one might presume the laws of the states were controlling. Still, their initial tasks involved creating through law a genuine government, where before there had generally been only committees established by the old Congress, a government in which they, as legislators, could not simultaneously serve. Chartering the Bank of the United States, though particularly controversial, was in this mode, not making rules that would govern the operation of society itself, but creating instruments that would themselves administer affairs. Second, the framers were intentional about what they considered appropriate for legislation, specifying not only the substantive areas over which the federal government could act, but in some instances, the mode of action. So, for example, insisting that the legislative power included the power not only to tax and borrow, but to spend. Remember this clause: no money shall be drawn from the treasury, but in consequence of appropriations made by law. To be sure, as Publius wrote in Federalist 82, quote, time alone can mature and perfect so compound a system, liquidate the meaning of all the parts, and adjust them to each other in a harmonious and consistent whole. How precisely the government would function could not be fully specified in advance, in other words. Nevertheless, the text of the Constitution and the legal context in which it was written are essential to keep in mind as we turn now to the question of executive orders. And I'm going to talk about 4 kinds of executive orders. Well, no, first, an introduction on executive orders, okay, and then 4 kinds. Although the government did not begin to number executive orders until the 20th century, the practice of presidents issuing orders apparently goes back to the administration of George Washington. The logic behind them is simple. Since the president is given the whole executive power and charged to, quote, take care that the laws be faithfully executed, he must be able to tell the members of the executive branch what to do. As one might expect, most of what the American Presidency Project, this is an important website, lists on its website as early executive orders are in fact military orders, which today would not be counted in the formal list of numbered executive orders published in the Federal Register. In their accounting, the honor of being listed as Executive Order Number 1 is accorded to Abraham Lincoln's February 14, 1862 order, releasing on parole all political prisoners held by the military. It's not hard to see that the condition of civil war would obscure the distinction between military and non-military matters. It's also not hard to imagine that when the federal government grew, so would the frequency of executive orders. Presidents in the first half of the 20th century averaged between 145 and 307 orders per year, but the number fell with Eisenhower and remained in the range of 30 to 80 until Donald Trump's second term. So let me say that again. In his first term, Trump simply issued the number of executive orders that was common among the presidents before and after. Of course, not all orders are equal. Some set a day of public mourning or public celebration, while others initiate large-scale restructuring of government itself, as, for example, Harry Truman's order desegregating the military and also the federal civilian workforce in 1948. Nevertheless, what the executive orders have in common is that they generally address the government itself rather than the general public, rather than us. That is what distinguishes them, at least formally, from laws. What complicates matters is, first, that there are also laws which address the government and its officers. Remember that phrase about execution in the necessary and proper clause. And second, that orders to government officials affect the lives and activities of the people with whom government interacts, of course. These are matters to keep in mind in the survey that follows of these principal orders, or some principal orders in the first year of President Trump's second term, or first year and a little more of his second term. So first I want to talk about his orders concerning immigration. In this area of immigration, an issue arose not long ago when President Barack Obama issued a pair of widely discussed presidential memoranda after immigration reform stalled in Congress in 2011 and 13, known by their acronyms DACA and DAPA, which were designed to defer deportation of undocumented adults who had been brought to the United States as children and of undocumented parents of children born in the United States, respectively. So DACA was for the children born outside but raised in the U.S., DAPA for the parents of children born in U.S. as citizens. These faced various court challenges, rescissions, and reissues over the following decade. DACA apparently remains in effect, as best as I can tell, though I suspect it's not widely used because it involves telling the federal government that you are undocumented. Yeah, I hope somebody would kind of laugh at that one. So, probably something most people aren't eager to do, even if a certain agency is tied up at the airports right now. While DAPA was blocked from the beginning by the judiciary. But in both his first term and his second, President Trump has used executive orders to address immigration, beginning his first term with his, quote, Muslim ban, which in modified form was actually upheld by the Supreme Court, and beginning his second with Executive Order 14,159. So that's where we're up to, the executive orders, and to the tens of thousands. And that's an order revoking immigration orders of the previous administration and ordering decisive enforcement of federal immigration law. A second order, also issued on Inauguration Day, EO 14160, aims to deny claims to birthright citizenship on behalf of children born to undocumented parents 30 days or more after the order was issued. This reached the Supreme Court quickly on its shadow docket, the second one, leading to the decision in Trump v. CASA last June that struck the use of nationwide district court injunctions to block administration policies, though leaving the issue of birthright citizenship to be litigated on the regular docket this spring, and it's before the courts now. Subsequent orders have addressed more particular issues, including the order to establish a Trump Gold Card, remember that one, that can be purchased to allow expedited processing and U.S. residency for immigrants upon payment of $1 million. No, it's $1,015,000. Right, that's probably the processing fee, the $15,000. At this writing, most of the controversy, of course, surrounds the activities of the U.S. Immigration and Customs Enforcement, ICE agency, and its tactics and deployment. Whether legal challenges include objection to the executive orders themselves or depend on claims of violating existing legal and constitutional rights, I'm not sure, but I think the challenges are mostly to the legal and constitutional rights, not to the orders themselves. Now, there is no doubt that power over naturalization belongs to Congress. It's enumerated in Article 1, Section 8, and this generally has been seen to include a general power over immigration, even though just naturalization is mentioned. Though the context of the clause suggests that the key concern is actually uniformity among the states, not inclusion or exclusion. But the issue in the first of those orders I mentioned is not, as it was for the Obama administration when the DREAM Act was pending, or arguably the first Trump administration when imposing its Muslim ban. The issue is not of this first order Trump issued, is not to change the law by executive order, but rather to insist on its enforcement and specify responsibilities of various government officers in the process. This seems to me altogether unobjectionable on legal grounds, whatever one thinks about the tactics employed as a matter of policy. The extent to which constitutional due process requirements are satisfied by immigration statutes is, of course, a separate issue. To my knowledge, the various lawsuits alleging violations do not address the legality of the order itself, just of the underlying rights. It should be noted, too, that by greatly increasing funding for immigration and border control, while establishing a new schedule of fees for immigration and for immigration hearings, Congress, in the so-called One Big Beautiful Bill Act last summer, effectively endorsed the president's enforcement policy. The executive order this first executive order thus seems a textbook case or example of the appropriate use of the executive order format, focused as it was on the execution of the law, not its redefinition. The second order, however, the one on birthright citizenship, is different. Here, the administration is attempting to change the long-established interpretation of the Citizenship Clause of the 14th Amendment. I will not say it is outright impossible to issue an executive order that is based on a revised interpretation of the Constitution, even if it alters a long-standing interpretation. Arguably, this is what underlay President Truman's 1948 executive order desegregating the armed forces and the federal workforce, the latter reversing a policy put into effect by President Woodrow Wilson's executive order 35 years before, which itself reversed a policy of similar standing. Right? And I think maybe on all cases, maybe not the Wilson, maybe he wasn't saying segregation was constitutionally required, just promoting it as a policy. Truman, I think, though certainly in favor of a policy of desegregation, was also acting at a time when the litigation over the constitutionality of segregation was proceeding up through the courts, and the first cases having already been decided and the others coming up through the courts at that very moment. Moreover, the birthright citizenship order was carefully drawn as a legal matter. It applies only prospectively, so it won't affect anyone who was born before the order, and then only after that specified future date, 30 days later, which was presumably to allow mothers who came to the U.S. in hope of gaining citizenship a decent interval to return to their native land to give birth, now that they weren't guaranteed that they could have an anchor baby, as they used to say. As I mentioned, the case is now in the courts, and as I understand the situation, the bets are whether the court will strike the order as a violation of the 14th Amendment itself, or whether it will strike the order as exceeding the president's authority in the absence of a congressional statute specifying what counts as being, quote, subject to the jurisdiction of the United States at the time of birth, which is in the clause of the 14th Amendment. If the latter option is chosen, that is, if the court says not that that the president's interpretation of birthright citizenship is unconstitutional, but just that Congress would have to define citizenship in that way, not the president, then it will be a landmark decision on this sort of political science question of, or separation of powers question, of the line between legislation and execution, between what statutes and what executive orders can do. Second set of orders I want to discuss are those that concern the management of executive administration generally. There have been numerous orders of this type, and it's the typical case for the resort to the device. Remember, I said the reasoning behind executive orders is the president should be able, since he has to secure that the laws be faithfully executed, he has to be able to tell people in government what to do if he's going to be in charge of it. But the particular cluster I want to address in more detail, or a little bit in detail, is the establishment of the so-called DOGE. Remember that? The, quote, Department of Governmental Efficiency, which was set up by an executive order on a temporary basis to supervise the reduction of federal spending and the federal workforce, also the subject of over a dozen executive orders. Although numerous lawsuits suspended some of the spending cuts and firings, many federal workers took advantage of the offer of a, quote, buyout. Quit now and receive pay through the end of the fiscal year. And Congress's, quote, big beautiful bill passed over the summer of 2025 made some of the cuts permanent and restored funds for numerous other programs of federal grants. One prominent lawsuit challenging the impoundment of funds, Global Health v. Trump, was dismissed by the D.C. Circuit on technical grounds, and Congress passed the Rescission Act of 2025 in July to make the matter moot by following the procedures of the 1974 Budget Control and Impoundment Act, that is to say, to make moot some of the rescissions that is, say, taking back of money that had been appropriated. The size and complexity of the cuts to budget and workforce make assessment unwieldy, which seems to have been part of the administration's plan in itself. Some funds have continued to flow thanks to court injunctions. Other issues await trial under regular process, and congressional action seems likely at this writing, to some extent has already taken place, to sort out what will be spared and what eliminated. It's, of course, too soon to know what the longer-term consequence for federal governance will be, though it can probably safely be said that the episode involved a dramatic use of executive power to reset the agenda and seriously, if not permanently, revamp the personnel of the federal government. Depositions the other week in a lawsuit concerning DOJ's cancellation of National Endowment for the Humanities grants apparently revealed the, how to put this impartially, unbureaucratic, if not downright careless mode by which DOJ agents operated in canceling grants. Still, the initial order establishing the unit was carefully drawn, legally grounded in an established statutory framework and explicitly designed to be temporary, which it was. It's now been dissolved. Presidents have long established special commissions for particular purposes, including at the beginning of several administrations, to trim regulations and cut waste. And while these have usually also involved corporate executives, they've often concluded just with recommendations, and certainly none operated so dramatically or inventively or with such immediate effect. Whether Congress investigates its operations, that is to say the DOJ operations, depends, of course, on who holds the majority after this fall's elections. The incumbent Congress seems to have welcomed the effort by the executive to cut things that many of its members wanted to cut but were unable to eliminate through the legislative process. If the courts find the whole enterprise to have been extra-legal, it will impose a novel restraint on the use of executive orders, I think, in executive branch restructuring, which has always been the core of executive order. But then novel actions do precipitate novel law. The third area where executive orders were deployed that I want to speak about concerns the imposition of tariffs. Here, the matter went to the Supreme Court, which ruled last month in Learning Resources versus Trump that the president was not delegated powers by Congress to set tariff rates generally on the basis of the International Emergency Economic Powers Act of 1977. The decision is an interesting one, not least because the court had a 3-3-3 split. The Chief Justice and Justices Gorsuch and Barrett ruled on the basis of the major question doctrine, that is the view that ambiguous statutory ambiguous statutory language that delegates powers should not be read broadly when an issue of major importance, a major question, is there before them. But rather, instead, there should be required a clear statement of what the law is. The issue of delegating tariff power they held to be a major issue, these first three, but there was no clear mention of tariffs in the IEEPA, so the president is acting beyond his authority, they said. Justices Kagan, Sotomayor, and Jackson reject the major question doctrine, but they thought it was an easy case. No mention of tariffs, no implied delegation. The third opinion is by Justice Kavanaugh, joined by Justices Thomas and Alito. Kavanaugh argues that given the history of delegating tariff power to the president, stretching back to George Washington, in fact, he would say that the statute clearly enough did imply the power, despite the absence of the word tariff. And besides, he thought, the major question doctrine was inapplicable to foreign affairs. Justice Thomas also wrote solo, in addition to joining that opinion, and proposed an interesting theory that Congress can delegate non-legislative powers, and the original understanding, he thought, shows that power over tariffs was non-legislative. In other words, Thomas holds that Congress has some legislative powers, but it has some powers that aren't legislative in nature. And it can delegate those, but you can't delegate the legislative powers. Even though the court ruled against the president, it is likely that he will continue to claim tariff authority under other statutes. Kavanaugh mentions this, that judges were aware of this, and of course Trump did that exactly the next day. Or he's going to find an opportunity to appeal to Congress for the authority to continue his policy, which I think he'd have a majority would support if Congress said it clearly. The court explicitly did not hold that congressional delegation of authority over tariff rates is itself unconstitutional. No one said that. Finally, it would seem neglectful in an academic setting not to make mention of the administration's repeated pressure seeking reform of America's universities. Although several executive orders were issued concerning higher education, most of the action has involved the cancellation of grants under the allegation of civil rights violations, that is, the continuation of affirmative action programs in universities despite the 2023 decision in Fair Admissions v. Harvard and the failure to suppress anti-Semitism in campus activities as well. And the administration is acting under the long-established but rarely invoked laws that condition federal funding on the absence of discrimination. Here, executive orders seem to be operating indirectly. First, through a general executive order against the use of DEI in federal programs and rescinding older orders requiring affirmative action, and then issuing letters, not orders, from the Department of Education or the National Institute of Health. Although a few of these complaints are in court, most visibly the case concerning Harvard, many universities, although they've spurned the Trump administration's proposed compact, are reaching individual agreements with the federal government to release the research funds. Whether lasting reform is achieved by these means, or whether a precedent for vigorous political interference with universities is the chief legacy, I think is still too soon to tell. I think the story here will be important, even just on the question of affirmative action and DEI. Like the birthright citizenship matter, the administration is operating on a very different view of the law and the Constitution than administrations had in the past. So it's a change of interpretation in the law that's now being implemented by executive order. But this time, in contrast to the birthright citizenship issue, they are following a major Supreme Court case and claiming to enforce it, not inviting a case with a novel view. At the very least, this gives additional credence to Howell's argument that the president's unilateral actions happen with an eye both on Congress and on the court. In conclusion, it might be said that the creative use of executive orders by the Trump administration has ample precedent in previous presidencies, even if not employed with the velocity or skill evidenced in Trump's second term, in contrast on that latter point to his first. One interesting question is whether the policy reforms promoted by the various executive orders will outlast his day. Legislation is hard to pass, but it's also hard to repeal, while executive orders can and often are rescinded on the first day of the next administration. Here, President Trump has had some success in turning his orders into legislation. That One Big Beautiful Bill Act put into law, at least through appropriations, the priorities indicated in a number of the orders. Moreover, although the verdict on the legal status of DOJ and its actions will not be decided for a while, without doubt, he altered the character of the federal workforce, not least through the ingenious measure of allowing government employees to stay home through September if they would agree to quit at the end of the fiscal year. a Machiavellian cynic might say, the conservatives have always said the government employees don't work, so let's pay them not to as long as they agree to quit. At the same time, I think the president has shown his opponents how to wield the tools of the federal executive should, or rather when, they return to office, even beyond what they may have been said to have shown him how to do, for example, through the Biden executive orders mandating vaccines, or to take a negative example, one where he failed, seeking to forgive student debt. The larger question is the extent to which, in the contemporary world, stability and lawfulness in governance remain goods that constitutional democracies ought to value, regardless of short-term partisan advantage, electoral or psychological. In part, this is a question of whether Congress can regain a sense of speaking for the people, which might in turn require recovering some sense of national unity that transcends partisan majorities, something that in the past might actually entail that the electoral creation of a majority that is larger than 50% plus one. John Locke wrote that in the beginning, all government was prerogative, and that the legislative power arose in response to it, partly to restrain prerogative abuse, partly to provide predictable order, that is, his settled standing rules, making possible a market economy, and partly, I think, to vindicate what James Madison calls, quote, the honorable determination which animates every votary of freedom to rest all our political experiments in the capacity of mankind for self-government. How to balance that noble ambition with a parallel claim of individual capacity and ambition is a perennial issue, not a peculiar quandary of our unusual, but not all that unusual time. Thank you. Go ahead.
I have a question about DOGE and USAID. So, if Congress created USAID through like the Foreign Assistance Act, can the president like effectively abolish it via executive order by broadening cuts through an advisory body whose director was like never Senate confirmed? Because I feel like that violates the appointments clause in the separation of powers.
Yeah, that's good. Very good. So many of the DOGE cuts, the ones that were most dramatic, concern this Agency for International Development, right? And I think they canceled all their grants, or almost all their grants. I think Congress restored a few of them, right? The money for AIDS prevention in Africa, for example. But they'll now operate through a different agency. So it's generally been thought that the president has some discretion in deciding how the law will be enforced. It really is this two sides question. On the one hand, the Constitution says Congress can make laws necessary and proper to bring into execution. On the other hand, the president has the responsibility to bring it into execution. Something came down on this earlier this week, I think, a similar thing in this case in relation to student loans. Here, he wasn't proposing abolishing student indebtedness as his predecessor did, but he wants to move them to the Treasury Department because he apparently plans to eliminate the Department of Education. Probably, it's the thought, can he abolish an agency just by rescinding its grants? That seems pretty unusual, doesn't it? But I think Congress has effectively done the same, haven't they? I don't remember, did they actually explicitly abolish the agency in the summer, or did they just not fund it in the big, beautiful bill? I think they just cut the funding and they moved how it would operate, right? So I think the AIDS grants are all running through Secretary Rubio. They put it under the State Department. But I think at one point he was also made head of AID, so they may not have quite eliminated the department. I don't think they can in general. But on the other hand, the law says no discrimination in, this is the reasoning they use, says no discrimination in grants. The interpretation of discrimination has shifted from allowing or even requiring affirmative action to now forbidding it. and it's on those grounds that they want to make that shift. So I'm not going to say that, usually Congress will eventually abolish a department, I suppose, if only because usually you're paying people for something that they're not doing, but paying people for not working is actually a bridge they've crossed. So maybe that one doesn't matter. On the rescinding of, I actually always thought that impoundment, that the general view that impoundment is not allowed, that is, say, when Congress authorizes money to be spent, that it must be spent, and that the president has no control of it. That's never struck me as quite right, because actually, it's just as an executive matter, you can't always spend money as you're instructed to spend money, right? So Congress can appropriate money for building a particular bridge, but whether you can find the contractors, whether or not the engineering works as they expected it would work, it is a sort of a practical matter, that the law can't just make things happen. And that's why there's a difference, I think, between the kinds of law that were in common law, that govern ordinary life and govern basic matters of right and wrong, and these sorts of things that involve building things or making things or coordinating activities. So it seems there has to be some leeway for the president, whether or not whether it can go to the whole point of whole-scale cancellation on that level, I'm not sure. And I think some of that is being litigated. I mean, in practice, it didn't all happen, but some of it's being litigated. On the other hand, there is that question of foreign policy versus domestic policy, and there's no doubt that the president has more authority over foreign policy than he does over domestic policy. If he thinks that, I don't know if any of us would say, whatever you think of the particular grants, if anyone would say that if circumstances change from the time that Congress passed the grant in relation to foreign countries, that you just have to spend the money regardless, that doesn't seem to make any sense from a point of view of foreign policy.